Commingling. The Commingling of Funds is the title of this ethics presentation produced as a part of the El Camino College Spring 2021 Paralegal Seminar brought to you by Marlene Vasquez, Richard Kim, and Lawrence Collins. Commingling is the mixing of client and attorney funds. Attorneys have a fiduciary duty to keep client funds strictly separate and carefully accounted for. Mishandling of client trust funds is the most common complaint reported to the California State Bar. Commingling is a serious ethical, professional, and legal violation prohibited by California statutes, professional codes of ethics, and case law. Research trail. The legal rules governing commingling come from three sources of law: statutes, regulations, and cases. All three sources provide mandatory binding authority on the practice of law when attorneys handle client funds. First, let's look at statutes. The State Bar Act, found in California Business and Professions Code Section 6000 through 6243, govern the practice of law in the state of California. In Section 6100, the State Bar Act acknowledges and grants the California Supreme Court the ultimate supreme authority over the practice of law in the state of California. Section 6076 authorizes the State Bar to regulate attorneys. Section 6077 provides that the rules of professional conduct are binding on all attorneys. Relevant to our discussion on commingling, Section 6091.1 expressly states that overdrafts and misappropriations from attorney trust accounts are serious problems. Moving on to regulations. The rules of professional conduct are the primary body of regulations that govern the practice of law in the state of California. The rules of professional conduct have been approved by the California Supreme Court and are binding on all attorneys, as expressed in the State Bar Act. Relevant to our discussion on commingling is Rule 1.15 under Chapter 1, Lawyer-Client Relationship. Rule 1.15 is titled Safekeeping Funds and Property of Clients and Other Persons. The California State Bar has summarized the essence of Rule 1.15 in this way. Client trust accounting is a non-delegable, personal, fiduciary responsibility to account for every penny. The key components of Rule 1.15 are: client funds must be placed in a client trust bank account in the state of California and labeled under the client's name. Whenever money enters the account, the client must be promptly notified. Whenever the client wants to withdraw funds from the account, the attorney must deliver the funds promptly. Funds must be kept separate, no commingling. The attorney may not withdraw funds until the attorney's portion is fixed and undisputed. The attorney must keep careful accounting with records kept for 5 years. So statutes, regulations. Now for the third source of law, case law. Case law. The California Supreme Court has emphasized the relation between attorney and client is a fiduciary relation of the very highest character. And one of the fiduciary duties that attorneys owe to their client is client trust accounting. And relevant to our discussion on commingling, commingling is an ethical principle that is considered to be a very serious ethical principle by the California Supreme Court, with potentially serious consequences for the attorney. And this is emphasized in the over 100 commingling cases decided by the California Supreme Court against attorneys in disciplinary actions. In our ethics presentation, we will present to you 2 California Supreme Court cases that illustrate the importance and the consequences of commingling. Johnstone versus State Bar will be presented by Marlene Vasquez, and Vaughan versus State Bar will be presented by Lawrence Collins.
As Richard stated, I will be discussing the case of Johnstone versus the State Bar. To begin, here are some of the facts in the case. Thomas Johnstone, the petitioner, was charged with violating his oath and duty as an attorney, commingling funds, and turpitude and dishonesty. The petitioner represented his client, Mr. John N.C., in an action for personal injury that occurred in an industrial accident. His client had collected workman's compensation benefits from the indemnity company during his disability, and that company became entitled to a lien in the amount of $4,945.57 against any recovery from the personal injury action. Petitioner negotiated a $3,000 settlement, and the industrial indemnity company agreed it would release and discharge its lien in exchange for $1,000 of the funds recovered. On or about March 6, 1963, the petitioner received the $3,000 payable to himself, NC, and the industrial company, and he deposited the draft in his trust account. At the time of the hearing, petitioner had failed to pay any of the $1,000 share to the industrial indemnity company. On October 1963, however, a check of the amount, $1,000, had been drawn by the petitioner of his trust account in favor of and delivered to the industrial indemnity company, but upon presentation, it was dishonored for lack of sufficient funds. The State Bar found Johnstone willfully mishandled certain funds received and held by him in trust and was suspended for a period of 3 months. Johnstone appeals the court's decision to the appellate court and asked the court to review his 3-month suspension. Some of the rules that the court went ahead and looked at were the Business and Professions Code 6103, 6067, 6068, 6106, and the Rules of Professional Conduct of the State Bar, Rule 9, which deals with the commingling of funds. Richard went ahead and explained earlier how they apply those rules to commingling cases. But here are some of the things that the court considered when making their decision. One of the cases was Haley versus State Bar, which has similar facts to our case. The attorney was suspended for 1 year for the misappropriation of funds coming into his hands in a compromise of a personal injury action against which he knew the State Compensation Insurance Fund had an interest pursuant to its lien claim. Another case was the Shulman versus the State Bar. The attorney was placed on probation for 3 years due to his failure to meet obligations for money borrowed from clients in a transaction not involving their attorney-client relationship. When an attorney receives money on behalf of a third party who is not his client, he nevertheless is a fiduciary as to such third party. Thus, the funds in his possession are impressed with a trust, and his conversion of such funds is a breach of trust. The petitioner claims that he represented NC only in the personal injury action, and NC negotiated directly with the industrial indemnity company for the compromise of the lien claim, termination of workman's compensation benefits, and his client was the one who entered into the agreement compromising the various claims and requiring the payment of $1,000 to the company. The petitioner claims that he himself had no knowledge of the arrangement until after he had settled for the personal injury claim. So he also said that NC requested the petitioner to act on his behalf to set aside the settlement and directed the petitioner not to pay the industrial company and instead use those $1,000 to pay other obligations owed by NC. And after all that NC left the country and he couldn't be located. The court looked at these very conflicting statements, given the testimonies from the claims supervisor, the employees of the company, and factual findings from the board. For example, while negotiating the personal injury claim, petitioner had inquired of the industrial indemnity company as to the extent of its lien so that he could take it into consideration in attempting to effect a compromise with the tortfeasor. And it was then agreed that the petitioner, the company, and NC would each receive $1,000 of the $3,000 settlement. It is also undisputed that the petitioner forwarded the $1,000 check. It just happened to be dishonored. So there is no factual support to his further contention that he was directed to use the $1,000 to pay other creditors. The record is silent as to any testimonies of such payments, and there was no effort in showing any part of the funds was devoted for that purpose. The court so then decided that the petitioner failed to sustain his burden of showing the findings of the board are not supported by the evidence or that its recommendations are improper. He also failed to sustain his burden of demonstrating lack of support for or lack of justice in the recommendation of the Board of Governors. The recommendation is then appears to be fair, just, and appropriate, and the petitioner is to be suspended from the practice of law for a period of 3 months.
In Vaughan versus State Bar, attorney George Vaughan sued the California State Bar for disciplinary action. The bar had sentenced Vaughan to public reproval in response to his actions in 2 separate matters. I will discuss the Williams matter. In the Williams matter, The client had hired Vaughan in a personal injury lawsuit against Dr. Williams. Vaughan agreed to place his client's money into a client's account, and Williams would receive medical fees from that amount. They settled for $9,500. Vaughan placed the money into the client's account. He sent $850 to Williams for medical fees, but Williams initially rejected it. He later agreed to accept the $850 and received the check over 1 year later. During that time, Vaughan had made multiple withdrawals from the client's account, which left the balance below $850 at least a dozen times. Vaughan claimed the money was not withdrawn for personal use, so he had not commingled the funds. The issue is whether Vaughan commingled his client's funds by making withdrawals which left the client's account balance below the required $850. Just like in Marlene's case, the court looked to the contemporary code of ethics, the professional rules of conduct. Rule 9 stated in part, "A member of the state bar shall not commingle the money of a client with his own. He shall promptly deposit his client's funds in a bank account separate from his own account." Rule 9 required that Vaughan place his client's funds into an account specifically for those funds. Following the $9,500 settlement, Vaughan placed the funds into the client's account. Approximately $4,800 went to the client, with the remainder available for repayment of Dr. Williams' medical fees. As this repayment had been agreed upon prior to the settlement, Vaughan had a duty to maintain a sufficient balance in the client's account until payment. Vaughan offered $850, which Williams eventually accepted. This acceptance established the amount which, at a minimum, needed to remain in the client's account at all times. In the approximate 1.5-year period from Williams' acceptance to the receiving of the $850, the client's account balance fell below $850 as many as 37 times. Vaughan claimed that the withdrawals were made as a result of attachments to the client's account. Even granted this, the balance fell below $850 12 times for reasons unrelated to the attachments. Whether 37 times or 12, Vaughan had allowed his client's account to drop below the necessary amount. The settlement had provided funds sufficient for the repayment, but Vaughan's use of his client's money had created deficits. Instead of safekeeping his client's funds, he prevented his client from fulfilling their contractual obligation. This potentially made the client vulnerable to future prosecution. Vaughan had placed the money into his client's account, but had improperly maintained it. The court found that an attorney does not have to use client's funds for personal use to constitute commingling. The failure to use a client's money in the way intended is sufficient. The court stated simply, Vaughan converted the $850 belonging to his client and willfully failed to keep deposited in a client's trust account said $850, as required by Rule 9 of the Rules of Professional Conduct. The court affirmed the public reproval against Vaughan. In summary, commingling is the mixing of client and attorney funds. Attorneys have a fiduciary duty to keep client funds strictly separate and carefully accounted. The misuse of funds is sufficient for commingling. Commingling is prohibited by California statutes, Professional Code of Ethics, and case law. Rules of Professional Conduct 1.15 specifically address commingling. These rules are binding on all attorneys. The California Supreme Court is the ultimate authority on commingling. Discipline for commingling includes suspension from the bar and reproval, among others. This has been the Spring 2021 Paralegal Seminar Ethics presentation on commingling, brought to you by Richard Kim, Marlene Vasquez, and Lawrence Collins. Thank you.